The Privy Council hearing of the incarcerated dancehall star Adidja Palmer, more popularly known as Vybz Kartel, and his co-accused goes to show that the Jamaican justice system is lacking in many areas. Hi again and welcome. This is Links 007 TV Let's Talk, and we're about to discuss this on the program. If it's the first time you're watching, please remember to like, share, subscribe to the channel. Click that notification bell and click on all so you're always updated with our latest report. We'll be right back after this short break. Welcome back and thanks for joining us for Links 007 TV Let's Talk. This is the place where we discuss issues of national importance, global importance, or the situation that are buzzing in the news. So the appeal of Vybz Kartel, the two-day hearing has concluded, and many fans right now are just awaiting the outcome based on the circumstances surrounding the whole entire case itself and what happened in the Privy Council in the UK. The Privy Council convened the hearing of the appeal in the criminal case of Adidja Palmer, more popularly known as Vybz Kartel, and others on February the 14th and 15th. It is important to start from the basis that the arguments from both sides are sent to the judges ahead of time, and therefore they are familiar with the main talking points of both the counsel and also in the appeal case itself. The appeal itself stands as the test of those arguments. Additionally, there is no rehearsing of the crime itself. The process is to review the trial process and whether it holds up with legal scrutiny. There was some contention discussed in relation to the telecommunication evidence and whether it was incorrect in law to have allowed it at the trial that was held in Jamaica some years ago. The defense, in contending that the evidence was not garnered in keeping with the relevant laws and legislation of Jamaica, they also sought to establish that what should be the precedent of legally obtaining the telecom evidence. The Privy Council panel made a point to highlight whether the evidence can be said to be essential to the conviction. This argument is usually an examination of the effect of the alleged breach and whether without the breach it is likely that the conviction still would have been reached. That extent is to be contended by the panel. There was a separate incident in which a juror was previously released from the jury and therefore the dismissal of another juror that was accused of accepting to bribe. That would lead to a mistrial as the number of jurors would be less than what is required. Additionally, the juror accused of accepting the bribe has subsequently been convicted in relation to the said bribe, and it is argued that this compromises the validity of the conviction. So this was a key point for the defense team representing the incarcerated dancehall star Vybz Kartel. So let me break down this in some stages for you to get a better understanding of what took place. So the initial trial of the incarcerated dancehall star Vybz Kartel started out with 12 jurors. However, one was dismissed for unconfirmed reasons. So the reason why one juror was dismissed from the actual trial of Vybz Kartel is still unknown. However, there were 11 jurors remaining in order for the conviction of Vybz Kartel to go through. So during the trial of Vybz Kartel, one of the longest trials in Jamaican history, lasted for around 64 to 65 days, I believe. And with that said, this have given the prosecution some time to order garnered certain evidence against the actual crime itself, and also there have been reports of evidence being fabricated allegedly. However, with the case in process and such in an advanced state, many believe that the judge actually went ahead with the whole entire trial just in order to not have a retrial of the case itself. So it became known that one of the jurors was actually bribing others in order to come back with a not guilty verdict in the initial trial stage, and that became known to the judge and also other members that were a part of the court system. We're about now to provide you with an insert of an update from the lawyer representing the incarcerated dancehall star, Mr. Isaac Buchanan, who provided an update after the actual appeal hearing.
Test to show that when you speak about the Constitution, it's your Constitution. They don't know it. The Lords respectfully don't know it. But when our Chief Justice says, listen, this is homegrown. This was made by us, the people, for the people, by the people, not from our colonial masters. to have us escape slavery, knowing that when we escape slavery and on the road to independence, we had to make sure that the least among us would be treated as humans. Because all of we now gonna have money, you know. But I can tell you, say, all the riches, the silver and gold will vanish away, but a good constitution will never decay. And the creatures of the constitution can never abuse you when the constitution is working. So what happened February 14th and 15th? The working of the Constitution, the showing up of a disgraceful moment where the constitutional rights, not now, because I can tell you this with pride and authority, that in Jamaica, the court, and you can ask the people who are always on, whether it be the Rattigan show or previously the Andre Stevens show, any one of these shows, when I appear on these platforms and we talk about the Constitution and talk about the judiciary, it works. So the complaint being made on the Vybz Kartel case was when the charter was just changed. Is when we were getting rid of the wickedness and the bad mind and the corruption. Corruption still there now. It's in your parliament. The six don't come out yet. But the corruption within the police force, the use of the man phone, the tampering of technological information. And then you have, we soon talk about the jury. When you put people who deal with police, husband and wife upon the jury or the police where responsible for security, soldier upon the jury, woman where sleep floor but her man a police, and the mix up, and then woman where own funeral parlor where walk up the street but had a cell phone and she's the this and she's that. All of them mix up here going, you know, real thing. And these things is what is the other side of the game. And so the right to privacy now is get your privacy, breach your privacy, then scandal you. It's called ad hominem. Scandal you and use information to shift the narrative in the public space and speak about circumstantial things that don't necessarily have inescapable inferences. But why I say all of this? Because a jury of your peers is all those things that I tell you. But the key aspect of it is a properly constituted jury. That is what we must think about. A properly constituted jury. So I go back to it now. And our Constitution, Section 16.1 says, whenever a person is charged, it's with a criminal offense, he shall, unless the charge is withdrawn, be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. You see that? Independent and impartial court. People must ask themselves, what is the independent and impartial court? Well, at the time it would have been the jury, at the time it would have been the judge, and at the time it would have been how the process works. The defense attorneys come in and the prosecutor is there and all of that. So
Chat, sorry for disturb, but drop
4
some
men
likes on the live,
charged
please.
for murder, not capital murder, murder simpliciter, and information collected, collated, and sorted by the police in breach of the Interception of Communication Act. And the Constitution, this Constitution, the Charter, and through the Charter, it says that to use this information, if it's not collected in the manner that the Charter prescribes, it must be demonstrably justifiable in a free and democratic society. That's the crux of the matter. Now, within this demonstrably justifiable in a free and democratic society, they said it's not. We don't need that. Them don't need that. Them boy don't need that. Them definitely, and we not do it. And the judge says, "Aren't you daunted?" Says to the prosecutor. He was in court today. Aren't you daunted by the fact that the people now have a powerful constitution that shifts the burden on you to tell us why you breached the right? And we know how it works because there's a case. There's a woman who had her cell phone, her son was murdered, and they wanted the code for the phone and all of that, and they go to court and all, they had to go to court, and then a judge does the test. So just like how it worked for Uptown, it must work for the ghetto youth. But it never works so for these four men. We go to the Court of Appeal and they say, well, but mind you, Charter young, people don't really interpret it yet. It came out at the time when
Lot of corruption, my people.
Constitution get nice when I was in law school. So we get a different type of training. We grew up knowing that the Constitution was the done of all done. So all this one done and skeng done and donna done and all Stefan done. Yeah, the Stefan done ain't no done like the Constitution. Them kind of things there. Right? It's what I said. The kingdom come from not Jada. You know, the kingdom, not Jada. You get what I'm saying. And yeah, and we ain't talking about Will Jada either. But you get where I'm going. So with all of this now, growing up knowing, as in growing up meaning in the law and knowing the importance of the Constitution, know about the importance of equality, the importance of treating your brother horizontally, with respect and human dignity. Everybody has that right. That was what was deprived for these men. And coupled with that, after that conduct, here comes the jury now. Incident number 2. Woman say, my son say him there jail with them. Because guess what? You know, everybody picnic can do no wrong. We see it on the TV every day. When the police murder them say, "My good youth, him not do nothing." Yeah, when you go around, you kill everything, and then when you dead, the news people report that you're a businessman when you's really the murderer, and all of that. But I'm not assassinating the character of dead people. I'm just saying is when for the purposes of creating a narrative, we do all kind of things and try to make people bad people good and good people bad. And that's why when you try to defame people, you find yourself apologizing. Or sometimes you just have to apologize because you don't want them beat you and kill you, because also then go on when them ready. And you must have self-check morality. You must know what suits you when you are doing what you're doing. So the key to that now is to not fall into the narrative of who's saying what. It's never over till the fat lady sing. But I can tell you this, man, the Bible don't lie. When God sent Moses for him people, him did know say he was gonna put Moses in the same castle, the same palace as the future Pharaoh, and that future Pharaoh was gonna have inferiority complex, because this Pharaoh had to be in the trenches. The Pharaoh is not of the ilk of Moses because he was raised beneath Moses. So when you can't be in as the ilk, when you can't do the law, you have to be in the trenches. And to be in the trenches, you have to delve into nepotism, because you can't respect the law when you're in the trenches. The trenches is dirt. The trenches is a pigsty. So anywhere in the space you hear somebody say, "I am in the trenches every day," because the executive, you can ask the parliamentarians when the only time you see them is election time. They're not in the trenches. That's why you need the councillors for to be in the trenches, and the MPs drive around in the big cars now and then from time to time, because they're too nice to be in the trenches. That's what we mean. So you say you're in the dirt and you're on the ground, you're the foot soldier and you're proud of that. It just means that you're not dealing with the legal aspects. You just a doer and a push your agendas. You're not. Yeah, that's what trenches mean. So you lose respect for the Constitution, you lose respect for the system, and that is what will cause a situation where a jury is tampered with.
When that became known in the Privy Council hearing that was held a few days ago, many questions were raised without answers, as it was very clear that this was a breach of the Constitution and that there should have been a retrial of the actual case itself based on the important roles that jurors play during trials such as these. This was a highly anticipated trial itself, and we should have garnered much attention. So this was actually a high stake case, and you wanted like the best jurors to be on this case. However, when it became known that there was a contaminated juror on the actual trial itself, the trial still went on based on the fast advancement of the trial itself and how the trial had gone over many weeks. However, when this was brought up in the actual Privy Council itself, the meeting that was held on February the 14th and 15th, it became known that this was actually a breach and that there should have been a mistrial. Despite all those evidence that were garnered during the actual court hearing and the conviction of Vybz Kartel, the court still went on and convicted the dancehall entertainer, knowing that there was actually a juror that was trying to bribe others with $500,000. Now, the Court of Appeal in their ruling and judgment are going to look on things such as these and whether or not this might have been a contributing factor that swayed the decision of the other jurors. So with that said, this juror was allowed to sit on the panel throughout the entire hearing of the Vybz Kartel trial and also with the submission of the conviction of Vybz Kartel. Now fast forward sometime after the actual trial and conviction of Vybz Kartel. This individual was actually convicted for his role in the actual bribing of others during the trial of Vybz Kartel. Now, how can you charge someone for a crime that was committed during the actual hearing and allow that individual to actually sit on the panel that made the decision of finding Vybz Kartel guilty? No, these are some questions that really need some answers, and it just goes to show you how our justice system is just so corrupt and not even to the point where you can even trust it right at this point in time. Because it's very clear that this should have not gone through. I'm not saying Vybz Kartel is innocent, neither am I saying he's guilty. However, the way in which and the manner in which the trial was actually dealt with, it does go to show you the unprofessionalism of the actual justice system and how maybe innocent people can be behind bars based on the inadequacy of how people deal with certain situations and how people can just bypass certain laws and regulation for their own personal gain. I strongly believe that the Jamaican justice system had a personal vendetta against Vybz Kartel. And it doesn't matter whether he was innocent or whether he was guilty of the crime he's accused and convicted of committing, he would have been found guilty whichever way and means possible. This is just so shocking to see how these revelations that would have came out in the actual Privy Council hearing itself a few days ago, and how certain rights might have been breached and how certain measures were not actually followed in the actual justice system. This case and the actual appeal itself has opened the eyes of many individuals to see how our justice system is so slack and lacking in certain areas based on when you look on circumstantial evidence that would have been there during the initial trial of the incarcerated dancehall star, and how certain rights might have been breached and how certain measures that are put in place in order to protect the justice system would have also been breached, and there have been many other questions raised about how the actual cell phone evidence was actually dealt with in the initial trial based on the fact that it became clear and known to the public that this cell phone was actually being tampered with during the incarceration of Vybz Kartel, and this was one of the prime evidence that was used to convict the dancehall entertainer. Now, with the Privy Council hearing all these submissions, it's very clear that Vybz Kartel will walk free. And I'm not thinking about a retrial for the incarcerated star based on the fact that these evidence were tampered with, they were altered, and so much things went wrong with this trial. And even though the prosecution and all those that were a part of the actual trial panel itself, they would have known about these misconceptions that were happening during the actual trial, and they actually just overlooked them all. And now when it comes to the Privy Council now, the Privy Council are unrooting all these factors that would have been a contributing factor to why the dancehall entertainer would have been found guilty. So during the Privy Council hearing, there was a general consensus as to whether the trial judge back in Jamaica during the initial stage of Vybz Kartel trial properly addressed the issue of bribery and whether the appropriate direction was given to them in light of the tampering. So what is necessary for the grounds of appeal is the proof of prejudice. Can you prove that this bribe actually swayed the minds of the rest of the juror? Was this potential bribe given attention by the judge and therefore renders the threat of the bribe as nullified? The panel will have to contend with the fact that the evidence suggested that there was insufficient and indecent warrant of a dismissal of the entire juror, and whether not doing so does to the heart of the conviction. In a case such as this that garnered so many scrutiny, the Privy Council would have ruled that this should have been a mistrial and that there should have been a retrial of the actual case itself, based on the fact that the judge known about the actual tampering and also the bribe, that there should have been a whole entire juror panel being reselected and a new set of juror being selected in order for a new panel to be convened and actually a new trial to be started. But based on the fact that this trial had been in an advanced state, no one wanted it to turn back, because at the fact of the trial itself, it was very clear that this trial would have been one of the longest trials in the history of Jamaica, and this would have cost millions of dollars in actually to have another hearing of this itself. And based on that factor, that might have been one of the contributing factors that led the authorities or those that are responsible for the justice system to know about all what was taking place and still let the trial go through. So with that said, the panel will now have to contend with the fact that the evidence suggested that there was insufficient indecent to the warrant of a dismissal of the entire juror, and whether not doing so does to the heart of the conviction. The argument would have to be clear as to whether the interference with the juror led to them being impartial and renders the conviction unsafe. The issue is the manner in which the bribes and other interference should have been handled, and whether what was done to cure the issue to a sufficient degree. There is also an issue of whether the duty of the judge to sum or give direction as to how they are to handle the issue can be delegated to the jurors foreperson. So this is where now the bombshell happened in the actual court itself, where the prosecution is contending that the president suggests that a bad juror does not require a dismissal of the entire juror. The panel, however, seemed to be concerned with that aspect, as they pointed out the possibility that the unbribed jurors would come back with a guilty verdict based on the fact that they want to prove a point that they were not swayed by the bribe. Day 2 of the appeal continued on the same point, and whether the non-dismissal of the bribed juror meant that the entire panel was biased and therefore will constitute a mistrial. There was also a heavy discussion as it relates to the expense of repaneling a fresh jury in a case that had already taken up 40 days of court time. There would be a legitimate concern that dismissing the juror upon discovering the bribe would not be in judicial interest, given the time already spent on the trial, and it was within the judge's discretion to leave the jury and give him warning to cure the potential bias. So in such a high-profile case such as this, and even other cases, this should not have happened, based on the fact that you found out that a juror was contaminated and he was actually trying to bribe others. It doesn't matter how long the case was going for. It could be 300 days, 500 days, it doesn't matter. Once it is brought to your attention that the jury is actually in some form of problems or situation have arrived based on the fact that this can be proven, then this entire jury should have been dismissed based on the fact that this one juror could have swayed the decision of others based on the high level of the investigation that have taken place it's very clear that this case did not try fairly, and I believe that Vybz Kartel will walk free. Now, with all that was said in actually the Privy Council hearing itself, can you believe that the prosecution is still holding the grounds that they believe that the verdict should be upheld? So the prosecution argued that the verdict still should be considered safe, as the judge's warning would be weighed against the knowledge of the bribed juror. Does that make any sense? It does not to me, because there's no way that you can find someone that is in a breach of a certain law, and then you're going to allow that individual to sit on the panel and come to a decision that will determine how an individual rest of his life is spent. No, I can't understand that. They pointed out to the panel that the local court of appeal have already weighed these same issues and had decided the conviction still to upheld based on the substantial handling of the case. They urged the panel to consider the local judges and would have a greater grasp of the local circumstances, and so it is important to give them the benefit of the doubt. So you're asking the court of appeal to give you, the local court, the benefit of the doubt when there were so many breaches of the local constitution and certain procedures that are supposed to be followed in court were not followed? Come on now. I believe that the DPP and that office really needs to look into this case and see how they mismanage this case, and this might have what is going to lead to the freedom of Vybz Kartel. So there was an issue of one of the accused not found guilty. So in the actual trial stage itself, you had Vybz Kartel, who is known as Adidja Palmer, you have Kahira Jones, Andre St. John, and Sean Storm Campbell. There was also another individual that was actually charged with actually the murder of Clive Lizard Williams. Now, this individual was the only individual during the actual trial itself that was found not guilty. This particular accused was said to be the one on whose behalf the bribe was made. It is therefore contended that the verdict for the other accused is therefore safe, as the interference to the juror was not in relation to the men who were found guilty. There is also the issue of the strength of the physical evidence, and that when assessed at its highest, the conviction is still safe. So basically what the prosecution is actually saying, and this is the office of Miss Paula Llewellyn, based on the fact that there was a corrupt juror and the actual case itself, they don't believe that this will actually or did deter the actual case itself from them finding the others guilty. However, one individual was found not guilty, and this was the one that the bribe was actually intended for. Now come on, does this make any sense to you guys? No, this is just one of those cases that I've been tracking, and I can tell you there is so much misconception that happened in this case that I believe that the Privy Council would have no other choice but to overturn the actual ruling that was done in Jamaica. In closing, the main test would be that of a fair-minded bystander. Would a reasonable, unbiased bystander think that the presence of one corrupt juror tainted the entire panel? This is the issue as the test, and the perceiving of citizens of their constitutional freedom of movement requires public trust in the system. Therefore, would a reasonable member of the public think that the bribe meant that the entire jury could not be trusted to be impartial? Now think about that. There is no evidence that the defendants were even the source of the bribe, and therefore it cannot be said that the bribe had any real effect on the juror. Based on accountability, it is said that the judge cannot assume that it was not impactful, and therefore should have discharged the jury to maintain the entire integrity of the whole trial process. There, of course, is an option to direct the case for a retrial. However, there were major issues with that direction. There would be an issue with the integrity of the evidence based on the passage of time, as well as the reliability of the witnesses. There is also the public profile of the accused, and the unlikelihood that a person would be on the juror would have an unbiased mind, and therefore would make the retrial unfair from the onset. So basically, with the Privy Council hearing all these arguments, it's not clear whether or not they will go for a retrial based on all the underlying factors. So a retrial would be off the books. So the only next thing standing right now is a dismissal of the actual case itself, and Vybz Kartel will walk a free man. However, we still have to wait some time for that to happen based on the Privy Council ruling, which will take 2 to 3 months in order for them to arrive at a decision. Now, with that said, we just have to wait for the Privy Council ruling. This has been Links 007 TV Let's Talk, and we look forward for your comments in the comment section. Thanks for watching.